Court call the case of the People versus Lisa Keebler.
Office for the people.
John Shea, Your Honor, with and on behalf of Lisa Keebler.
Lisa Keebler. Morning, Your Honor. I think it's still.
Okay. Go ahead, Ms. Blair.
Teresa Blair on behalf of probation. Your Honor, Ms. Keebler is before the court today for a violation of probation hearing. Ms. Keebler had a new arrest.
This defendant was already on probation. Then came another arrest, another alcohol allegation. Today, the court decides jail or total control.
OWI, date of offense of December 5th, 2025. There is alleged use of alcohol on that date. I did not know the PAC when I provided that documentation to the court for this hearing, but learned of it this morning. That blood alcohol level was 0.17. So the court is aware that Keebler was placed on a cram tether as a condition of her probation that was placed on her on December 11th, 2025. She's had no violations on that scram tether since. Given that the case is still pending, probation is recommending that the scram tether continue, that Ms. Keebler not go into any places that serve alcohol, that she have an interlock placed on her vehicle through Nationwide, that being today, that she report there directly after this hearing, and that the violation hearing continue or be adjourned to January 28, 2026 at 12 p.m. awaiting the new case being filed.
And Your Honor, for the record, I did review that new case, and I can confirm as of this morning, I completed the charging documents and the necessary warrant packet information.
Face forward.
Oh,
You're good.
okay.
Just step back.
Okay.
She's okay.
To charge an OWI third offense. It is an OWI third offense. I see that the defendant's priors are from 2014 and from 2025. So in that case, I have requested $25,000 cash or surety bond for that arraignment. It's a separate issue. In this case, because the defendant was on probation for an OWI related case and then picked up another one with a single vehicle crash into a ditch, people are requesting that she be remanded.
And as to the violation at this point, you're going to admit to that violation, is that correct?
Yes, Ms. Keebler is going to admit that she used alcohol on December 5th, and she will admit that she was arrested as well on December 5th. She is not making any admissions regarding how much she had to drink or anything like that, given the fact that we have a pending felony matter that's charged arising out of the same incident. But she doesn't have a problem acknowledging that she used alcohol that day.
Is that correct, Ms. Keebler?
That's correct, Your Honor.
All right. And the court will accept that admission. So that the record is very clear and that the crux or the majority of the in-chambers conference held with counsel and probation was revolving around, without getting into too much detail, certain cognitive issues and certain other medical issues regarding this defendant. And the court was significantly weighing and balancing a remand as opposed to some other type of process that could, or something that could be put into place, which both, well, fundamentally would stop the defendant's consumption of alcohol, but at the same time, which is paramount to the court, that ensure as best the court can the public safety. And I felt, after having heard from everyone, that the court's normal practice, which particularly this time of year might be a remand, that the court felt that given all of those circumstances, that another process could be put into place. That doesn't mean at a later date I might not decide that a remand might be appropriate, but at this particular moment, looking to do something a little bit different that more fits with this particular defendant. Paramount in that, and one of the things, and it was stressed by probation and also counsel for the defendant, was the fact that when there is stringent monitoring of the defendant does very well, and there is not the consumption of alcohol. It's when there is sort of a gap there that the alcohol happens. And so two primary issues for the court are the consumption of alcohol and then the operation of a motor vehicle. And when those two come together, that becomes even more of a problem. So I think we fashioned something that will address that, at least temporarily, for the time being. So what I'm going to do and what I'm going to order is I'll continue the scram tether. I will order no driving or operation of motor vehicle without an ignition interlock. I'm going to order that ignition interlock be placed on that vehicle today. You are not to drive any other vehicle that is not equipped with an alcohol ignition interlock. Do you understand that?
I do.
I will adjourn or set for a review, I guess, or continuation of the BOP hearing to January 28, 2026 at 12 p.m. I'm also going to order that you are not to enter any establishment that either sells or serves any type of alcohol. And I realize that that may preclude the entry into grocery stores and other places like that, but that is going to be the order of the court. You cannot go in. If grocery items and other things need to be ordered, they can be ordered. I would not find a violation if you were in the parking lot picking up and there's a pickup of something along those lines. However, you are not to be in those establishments. Is that understood?
I understand.
Is there anything else?
She admitted the violation jail was on the table. Instead, the judge locked everything down: movement, driving, alcohol, choosing control over incarceration.
Mr. Shea, anything else?
I'm just taking notes, Judge. No, nothing else. Thank you very much.
All right. Thank you. All right. Good luck to you.
Thank you, Judge.
They're awaiting you down at AAA for the install.
Yes,
You know where that's at?
I'll give them the address.
Keep going down Michigan Avenue. You'll see a yellow sign that says AAA. You'll see it. Okay.
Okay.
All right, thank you.
All right.
Thank you, Judge.
Thank you. Court does call the case of the people versus Justin Lang.
Ashley Pelvis for the people. Good morning, Mrs. Symbol, Attorney Lauren hearing on behalf of Mr. Lang. And Mr. Lang is not present. He advised me this morning that he is in the hospital at St. Joe's. He had a seizure. He did provide me with a copy of his bracelet thing. I don't know what they call it, but we did provide me
The admission bracelet.
Thank you.
Thank you. All right.
Yes, and I did show that to Mrs. Feltus. I did provide a copy of Ms. Hartwig for, I don't know if we want it for the file, but that is the latest update I have from him.
Were you satisfied with the picture, Ms. Feltus?
I'm sure it is what it is, Your Honor. I have no reason to doubt what Ms. Pirani is saying. I know the court recalls we set the state because Mr. Lang was going to be local because he does currently, I think, live in Texas, if I recall correctly. Houston, yeah. Houston, Texas, yeah. For what it's worth, I have not been able to have good contact with the apartment folks for this hearing. If the court recalls, we were hoping to get some information from Hamptons or Pines of Cloverleaf. I can't recall which one off the top of my head right now. So at that point, I think I would just request an adjournment so we can have everybody here and see if we can get an answer. And we're asking for a bench warrant.
All right. Non-jury trial in this matter. But he lives in Texas. How often is he up here? Do you know? Yes.
I know he was here because of the holidays.
Right. Well, why don't I do this and we can see if everything will work out. I'll just, when's my?
The next date is February 28th. I'm sorry, January 28th. And
I know that date is causing some difficulty for my office, so I was actually going to ask if we could look at February, if that would be okay for him in defense.
For your office?
Yes.
Fine.
We already waived jury trial, he say.
Final settlements are on the 6th. But
Yeah, well,
I don't have a problem putting this in the final settlement docket if the court would allow it.
yeah, why don't I do that?
Okay.
And then,
and I'll get in touch with him and the people, if anything changes.
Okay.
so what I'll do is this, I'll set the non-jury trial for February 20
It's February 25th.
25th, 2026 at 9. I'll set that date, but then I'll set a final settlement conference for February 6th,
Yes.
2026 at 9 a.m. And I'll list both of those as in person, but understanding that he may be in Texas.
February 6th, thank you.
Yes. Okay. Oh, that was fun.
She admitted the violation. Jail was an option. Instead, the judge chose structure over cell. In this courtroom, control became the last chance.